Hello everyone, I am Anuradha and welcome to LiveLaw. This news just came in. The Karnataka High Court has imposed costs of rupees 50 lakhs on Twitter in a petition filed by Twitter. The petition was filed against the orders issued by the Ministry of Electronics and Technology to block certain accounts and content under Section 69A of the Information Technology Act 2000. Section 69A of the Information Technology Act gives the power to issue directions for blocking of public access of any information through any computer resource to the central government. In the June of last year, the Ministry of Electronics and Technology served Twitter a letter warning them of serious consequences of non-compliance with the orders, including initiating criminal proceedings against Twitter's Chief Compliance Officer, and granted last opportunity to comply with a series of blocking orders. Failing to do so would lead Twitter losing its immunity as available to it under Section 79(1) of the IT Act as an intermediary platform. For context, Section 79 of the IT Act provides exemption to platforms such as Twitter or YouTube from liability for misuse of such platforms, which means that a company such as Twitter will not be held liable for crimes committed by its users if it complies with the government. After this letter was issued to Twitter, they approached the Karnataka High Court with a writ petition. Twitter had claimed that the blocking of the orders are, and I quote, procedurally and substantially deficient of the provision and demonstrate excessive use of powers and are disproportionate. Twitter asked how it could be directed to block user accounts and muffle their freedom of speech when news relating to these events were freely circulated by television and print media. Senior advocate Datar, while appearing on behalf of Twitter, also referred the landmark Shreya Singhal case, which declared the Section 66A of the IT Act to be unconstitutional, saying that if the court considered the Shreya Singhal case, if sender finds some tweet objectionable, it has to send a notice to the account holder asking why the tweet should not be pulled down. He had argued that blocking user accounts would be a violation of freedom of speech. He had added that the safeguards of the Shreya Singhal judgment could not be met unless the users have a right to examine if the correct procedure has been followed. Senior advocate Datar and senior advocate Ashok Haranhali, appearing for Twitter, had previously also submitted that if content is not falling within the prohibition under Section 69A, it cannot be blocked. According to them, such blocking orders not only affect the rights of the primary users of the website like you or me, but also intermediary itself, and so it was their case that Twitter is entitled to challenge the authorities' blocking orders. The central government opposed the petition filed by Twitter, challenging the blocking orders passed by the Government of India. Additional Solicitor General R. Shankar Narayan, appearing for the government, questioned the maintainability of the petition. He said, and I quote, "The petitioner, being a foreign company, cannot avail any remedy of fundamental rights guaranteed under Article 19(1) and Article 21 of the Constitution of India. The petitioner company does not have a legal mandate to espouse the cause of Twitter users or account holders." The ASG also submitted that news items appearing in newspapers is as per the discretion of the newspaper. However, on an intermediary like Twitter, anyone can put up a post and there is no discretion. In reference to Section 79 of the Information Technology Act, which we previously discussed in this video, it was said, and I quote, "Intermediaries are bound to obey the orders which the designated authority or agency which the government fixes from time to time." It was also said that the Twitter account holder is not carrying out business by writing out Twitter posts nor canvassing for business. He is only expressing his view. While justifying the government's blocking accounts, he said, and I quote, "Therefore, when the government seeks to block the account, the person who is actually aggrieved by blocking of the order is not carrying out business. He is merely expressing himself. Therefore, to say that you, that is Twitter, are covered under Article 19(1)A or 19(1)G will not be correct. On the contrary, the intermediary should distance itself from the account holder if there is an act of omission or commission." ASG Shankar Narayanan had further submitted that Twitter is a significant social media intermediary as per IT Rules 2021 and contended that as per Rule 4, it is required to comply with the order and perform their additional due diligences. It is worth noting that on the court's inquiry as if there is any provision for revocation under the Indian laws, Senior Advocate Datar also had to concede on behalf of Twitter that Rule 9(4) of the IT rules empower the Secretary to revoke the order, and an elaborate procedure for the same is available. Our regular audience may be familiar with the IT Rules 2021, or specifically the IT Intermediary Guidelines and Digital Media Ethics Code Rules 2021. These rules introduce several broad criteria to hold intermediaries such as YouTube, Facebook, or Twitter responsible for the content posted by their users. In recent memory, the Catch Masala case or the Aaradhya Bachchan case, along with the Kunal Kamra petition challenging the IT rules themselves, come to memory. We have extensively covered cases about this issue, and we will leave a link of important videos down in the description. The ASG also went on to highlight to the court that Twitter has not responded to their notices, and meanwhile miscreant users continue to post inciting content. The ASG added, and I quote, "It is the duty of the intermediary to provide details of the account holder." The ASG also relied on the Supreme Court's judgment in the case of Anuradha Bhasin versus Union of India and said that the aim here is that you are entitled to do whatever you want on your platform. Let all join. Let there be as many views as there can be. Let knowledge come from every quarter and let us enjoy it. But if it is going to affect the integrity, sovereignty of India, or is going to create a public order problem, then naturally we will step in and either we will issue a takedown notice or we will say block the account. A single judge bench of Justice Krishna S. Dikshit considered the arguments and refused to stay the operation of the orders issued by the ministry, and the petition filed by Twitter was dismissed. The court said, and I quote, "Your client, that is Twitter, was given notices and your client did not comply. Punishment for non-compliance is 7 years imprisonment and unlimited fine. That also did not deter your client. So, you have not given any reason why you delayed compliance more than a year of delay, then all of a sudden you comply and approach the court. You are not a farmer but a billion-dollar company." While dismissing the petition, the Karnataka High Court has imposed a cost of Rs 50 lakhs on Twitter to be paid in 45 days to the Karnataka State Legal Services Authority. That's all we have for you in this video. If you found this video informative, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. If you'd like to read our report, please visit our website at www.livelaw.in. We will also leave a link down in the description to the full report and the videos we previously mentioned. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.